My name is Jessie Hill. I'm the Associate Dean for Academic Affairs and Judge Ben C. Green Professor of Law here at the law school. And I'm really delighted to introduce our next panel on voting rights. Obviously, a very timely topic at the moment. And we are extremely lucky to have two preeminent scholars in voting rights and the law of democracy here for this panel. And in addition to that, they are both actually real lawyers as well. They're both actively involved in litigation. So I'm going to introduce both speakers and before I sit down, and then I'll get out of the way. Our first speaker will be Pamela Carlin. She is the Kenneth and Harl Montgomery Professor of Public Interest Law and co-director of the Supreme Court Litigation Clinic at Stanford Law School. She is a nationally recognized expert in the fields of constitutional litigation and the law of democracy, and she has excellent and highly regarded case books in both of those areas. She's also the author of a monograph on constitutional interpretation called Keeping Faith with the Constitution, and of dozens of scholarly articles. Professor Carlin received her degrees, her BA, MA, and JD from Yale, and she clerked for Judge Abraham Sofair of the U.S. District Court for the Southern District of New York, as well as Justice Harry Blackmun on the Supreme Court. She has served recently, during 2014 and 2015, as Deputy Assistant Attorney General in the Civil Rights Division of the U.S. Department of Justice, where she received numerous awards for her work on U.S. v. Windsor implementation and for working on the department's policy regarding Title VII and gender identity. She has also received numerous teaching awards. She's a member of the American Academy of Arts and Sciences, the American Academy of Appellate Lawyers, and the American Law Institute. Our second speaker is Daniel Tokaji. Dan Tokaji is the Charles W. Ebersold and Florence Whitcomb Ebersold Professor of Constitutional Law at The Ohio State University, Moritz College of Law. He is also a leading national authority in election law, as well as First Amendment in federal courts, and he's the co-author of a casebook on election law, as well as a nutshell on election law. He's published numerous law review articles on political equality, racial justice. His most recent publications are about soft money, responding to Shelby County, and about applying Section 2 of the Voting Rights Act to the new vote denial. He's also successfully litigated many civil rights cases and election law cases. He was lead counsel in an Ohio case that struck down an Ohio law requiring naturalized citizens to produce a certificate of naturalization when they were challenged at the polls. He's also currently involved in some ongoing litigation in Ohio. He's a graduate of Harvard College and Yale Law School, and he clerked for the Honorable Stephen Reinhart on the U.S. Court of Appeals for the Ninth Circuit, and before that was with the ACLU of Southern California and California Common Cause. He is often quoted in numerous media outlets. New York Times, LA Times, USA Today, and NPR have all quoted him for his expertise. So please join me in welcoming our first speaker.
I think they've asked me to swap in mine for yours. Well, this is like origami. Here, there. I'm not just a problem, I'm a problem solver. Well, it's a tremendous honor to be with you all here today for this symposium in honor of Fred Gray. As I was flying into Cleveland last night, the pilot came over the loudspeaker and said, we're going to be delayed a little bit because Air Force One is landing in Cleveland right now. And I thought to myself that Fred Gray is actually the reason both I and Barack Obama are coming to Cleveland today. Because John Lewis famously observed that Barack Obama is what's at the end of that bridge in Selma, Alabama. And Fred Gray was at the beginning of that bridge. Without what Fred Gray did and what the Voting Rights Act did, Barack Obama would not have been in Cleveland last night, nor would I. That Mr. Gray is here to celebrate with us today. And the reason for this is something that takes me to a song by the famous satiric songwriter Tom Lehrer, who once described it as a sobering thought that when Mozart was his age, he'd been dead for 2 years. And it should be an equally striking thought that when Fred Gray was 25 years old, he became the lawyer for the Montgomery bus boycott. And when he was 29, he argued his first case at the United States Supreme Court. And so basically he did it when he was younger than many of the law students in the audience today. So we should all ask ourselves what we had accomplished by that age. And the answer is precious little. I would be remiss, though, if I didn't pause for at least a moment to acknowledge the death earlier this week of one of Fred Gray's colleagues in those early cases, Jack Greenberg. In his autobiography, Bus Ride to Justice, see, I've brought my copy with me. You should all read this book. It's a terrific book. But in the book, Mr. Gray mentions that one of his greatest assets was his ability to obtain as co-counsel outstanding legal minds in many of his cases, and he points to Jack as one of those outstanding legal minds. Having myself had the privilege of working with Jack as a young lawyer, I agree that he was an amazing asset, and he will be missed. And so it's especially wonderful to be able to celebrate with you here today. Now, speaking of great legal minds, there's an interesting meeting between two of those great legal minds, between Chief Justice Earl Warren, who presided over that first case of Mr. Gray's, and Mr. Gray himself. And you see this convergence of their minds in their autobiographies. Chief Justice Warren wrote in his autobiography that Reynolds against Sims, the case where the Supreme Court announced the rule of one person, one vote, was the most important opinion he delivered during his tenure on the Supreme Court. And I wonder if anybody in this room other than Mr. Gray and probably David Garrow and perhaps Dan Tuskegee will remember that the Reynolds of Reynolds against Sims was Bernard A. Reynolds, who was the probate judge and the chief election officer for Dallas County, Alabama, which is where Selma was, the ground zero of the Voting Rights Act. And it was the place where Mr. Gray litigated Williams against Wallace, the case that led to the ultimate Selma to Montgomery march, the end of the bridge at which we find Barack Obama. Now, why did Chief Justice Warren think that Reynolds had this place as his most important case, rather than Miranda against Arizona or Brown against Board of Education? Well, he explained it this way. He said that Reynolds ensured that henceforth elections would reflect the collective public interest embodied in the one-man, one-vote standard rather than the machinations of special interests. Now, perhaps he was a little over-optimistic there, but he had a point, because voting, as the Supreme Court had held long before that, is our most fundamental civil right because it is preservative of all rights. Chief Justice Warren saw it that way and later remarked to one of his law clerks that if Reynolds against Sims had been decided before 1954, Brown versus Board of Education would have been unnecessary. Now, the idea here, which was also the idea behind a famous 1957 speech by Mr. Gray's famous client, Dr. Martin Luther King Jr., a speech called "Give Us the Ballot," was that if black citizens could vote and have their votes fairly counted, legislative and executive offices and judicial offices in the South, when they were elected, would be filled by persons who were responsive to black people's entitlement to equal treatment under the law. So that's Chief Justice Warren. Now take Mr. Gray in his autobiography. Mr. Gray, as you know, and you've already heard about a number of these cases, was responsible for litigating over the Montgomery bus boycott, which extended Brown against Board of Education beyond school segregation to the myriad other forms of discrimination in American life. He was at the center of litigating the case about the shameful Tuskegee syphilis experiments. He was at the center of litigating foundational cases involving both school desegregation and the desegregation of higher education in Alabama. So he had no lack of famous cases to write about in the book. And yet, he describes Gomillion against Lightfoot, a case I'm going to turn to in a few minutes, as in his words, and here I'm going to quote him, perhaps the most important civil rights case that I have had the privilege of handling. He points out that Gomillion was both the first case involving racial gerrymandering that the High Court had ever considered, and that it laid the foundation for the concept of one man, one vote that the court adopted 4 years later in Reynolds. Now, Gomillion is a very, 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 very famous Supreme Court decision. It's in all the Supreme Court, it's in all the case books about constitutional law or race and the law, and it's much discussed. There was a wonderful book about the case that grew out of a series of New Yorker articles that was written by Bernard Taper. And there's a great 2010 Law Review article by Case Western's own Jonathan Enton on this. But, as you might expect, it was not Mr. Gray's only voting rights case. However famous Gomillion is, almost as path-marking was a far less celebrated case, a case that I'm pretty sure only about 5 people in the room have ever heard of, and that's Smith against Paris. So in my remarks today, I want to look at the 2 cases for the way in which they illustrate another point that Mr. Gray makes in his autobiography. More than 50 years after his victories, we continue to confront the variations on the problems he confronted at the very beginning of his career. So for those of you who are worried that there's nothing left for you to do, don't worry. There is. So let me start with Tuskegee. On the eve of the Second Reconstruction, the city of Tuskegee, Alabama consisted, in Mr. Gray's word, of a square with sides 1.5 miles equal distance from the courthouse. So there's a square. It looked like Colorado or Wyoming, except with more black people. But however regular its boundaries, Tuskegee was an exceptional city along other dimensions. In a state where many black citizens were economically vulnerable and disenfranchised by an unfairly drawn and unfairly administered literacy test, Tuskegee was different. It had an active, highly educated black community, many of whose members worked either for the Tuskegee Institute or for a federal VA hospital. And those folks were beginning to register to vote in large numbers. And they were not economically vulnerable in the way that sharecroppers were, or people who worked in domestic service. And the white power structure in Tuskegee could see the handwriting on the wall. So it responded by getting the Alabama legislature to enact Act 140, which transformed the city from a square into what Mr. Gray called a 25-sided sea dragon, and Justice Felix Frankfurter, who lacked Mr. Gray's poetic gifts, called, in his unanimous opinion for the court, a strangely irregular 28-sided figure. And I've actually looked at the map, and Mr. Gray did something that was really quite innovative in his oral argument at the Supreme Court. He brought in a huge copy of the map and put it up behind him. And the Supreme Court seldom gets that real visual punch. But no matter how many times I've looked at the map and how many times I've counted lines, I have no idea how many sides Tuskegee actually had after the redrawing. Now, the consequence of this redrawing of Tuskegee's boundaries was to remove all but 4 or 5 of the city's black voters, while managing not to remove a single white voter from the city. The whole point of redrawing the boundaries was to exclude as many of these highly educated, civically militant black citizens as possible. So Fred Gray brought suit. Gomillion turned out to be the opening wedge in the Supreme Court's willingness to engage in judicial review of electoral boundaries. And the Supreme Court had very little trouble, it was unanimous, in holding the de-annexation, the redrawing of Tuskegee, to be unconstitutional. Justice Felix Frankfurter's opinion for the court rested on the 15th Amendment to the Constitution, which prohibits a state from denying or abridging the right to vote on account of race. Now, Mr. Gray's account of the preparation for the argument that he gives in his book reminds us of a path that was then not taken, using the 14th Amendment's Equal Protection Clause as the basis for striking down Act 140. In some ways, the 14th Amendment might have been a more natural home for Gomillion's claim. He and the other plaintiffs had not just been denied the right to vote, but they'd been denied a bundle of benefits stemming from residence in Tuskegee on account of their race. And of course, they retained the right to vote in every election where they still lived. They just didn't live in Tuskegee anymore. But locating the decision in the 14th Amendment rather than the 15th Amendment posed a risk for the Supreme Court, that it would then face additional challenges from other citizens who objected to the way governments drew political boundaries. And Justice Felix Frankfurter in particular was very, very reluctant to embark on incursions into what he memorably termed the political thicket. Now, here's what was interesting to me. Although Mr. Gray, who pressed within the litigation team to advance a 15th Amendment claim, describes his approach as a shotgun approach, have a complete arsenal of weapons, take aim, and shoot with everything you have. I guess you're also a big believer in the Second Amendment, at least as a litigation issue. 15th Amendment, the argument that he ultimately pressed and got the team to talk about, was actually more targeted. So the shotgun lawyer came up with a more pinpoint accuracy target because it focused just on voting and just on race. It left for another day the question whether political boundary drawing was an issue for the courts more generally. And Justice Frankfurter seized on this 15th Amendment opportunity. He wrote, while in form, this is merely an act redefining metes and bounds. If the allegations are established, the inescapable human effect of this essay in geometry and geography is to despoil colored citizens and only colored citizens of their theretofore enjoyed voting rights. That was no Colgrove against Greene, by which he meant that was no incursion into the political thicket more generally. Gomillion, then, marked the beginning of a Supreme Court distinction between political boundary drawing along racial lines and other sorts of political boundary drawing. It also marked the beginning of the court's use of what came to be known as retrogression as a way of avoiding standardless judicial intervention in politics. That is, you start with a nice clear baseline and you can say, this is worse than what was there before. So when the law makes things worse for aspiring black voters, courts should be especially suspicious. These two concepts continue to shape our voting rights jurisprudence today. In jurisdictions like Texas and North Carolina, legislators who've recognized a threat to their continued political dominance from the increased political participation by black and Latino voters have responded like Alabama did in the 1950s, adopting new district lines to prevent minority voters from electing their preferred candidates. They've also instituted new restrictions on the right to cast a ballot and have that ballot counted, what Dan Tuskegee has termed the new vote denial. Fortunately, courts have begun to respond to these stratagems, which involve states like Ohio and Michigan, as well as parts of the Old South, by recognizing that changing the rules to disadvantage minority voters implicates both the Constitution and the Voting Rights Act of 1965. Their use of prior practices and prior districts as a baseline has allowed courts to avoid having to figure out entirely for themselves which regulations of the right to vote are permissible and which ones aren't. Courts have come to treat expansions and cutbacks to voting opportunities as differently situated as a matter of law. In short, they recognize that when a state cuts back on voting rights, it needs to justify that cutback with something more than pointing out that a particular benefit wasn't constitutionally compelled in the first place. God did not require that the original Tuskegee be a square, but cutting away that square means something under the law. Same thing. There's nothing that requires early voting, but cutting back on early voting is a problem. There's nothing that requires drawing political boundaries on the west side of town rather than the east, but when that change results in black or Latino voters having less opportunity to elect their preferred candidates, that's a problem. Indeed, the Congress that amended the Voting Rights Act in 1982 recognized that in asking whether a policy is tenuous, one of the touchstones of whether that policy violates the Voting Rights Act, we should recognize in the Senate's words that if the procedure markedly departs from past practices, that bears on the fairness of its impact. That response, and the even more pointed response in the special preclearance provisions of the Act, that existed until 2013 came directly out of the Alabama experience of massive resistance, which Mr. Gray was so deeply involved in combating. Perhaps no case illustrates this judicial scrutiny of change more clearly than the Fourth Circuit's recent decision striking down parts of an omnibus North Carolina law that imposed a host of new restrictions on the right to vote. Just like the Tuskegee gerrymander, the North Carolina provisions, in the Fourth Circuit's words, targeted African Americans with almost surgical precision. For example, in the part of the bill imposing a new photo ID requirement, the state chose to allow the use of expired IDs for people over 70, U.S. passports, and veteran and military IDs, which were held disproportionately by white voters, while refusing to accept forms of ID like student IDs, government employee IDs, public assistance IDs, and expired IDs for non-senior citizens that were disproportionately held by African Americans. The state also targeted the forms of voting like early voting and same-day registration that black voters were more likely to take advantage of, while leaving absentee voting untouched. With respect to the distinction between racial and political motivations, the issues have grown more complex over time. Consider, for example, that in the 2008 presidential election, President Obama received 98% of the black vote in Alabama, but only 10% of the white vote. The state is clearly polarized, but the political and racial fault lines overlap one another. So if the Supreme Court is vigilant about policing the use of race, but diffident or reluctant to police overt political partisanship, we can expect to see litigators frame their arguments and justifications in the terms that advantage their claims. And indeed, that is what we have exactly seen. But that right to participate is not always enough to fully integrate minority citizens into the political process. Fred Gray's other foundational voting rights case, Smith against Paris, illustrates that point. The case comes from Barber County, Alabama, which was the home county of George Wallace, the governor who was most in charge of massive resistance in Alabama. That county, unlike Macon County, where Tuskegee was located, was majority white, but it had a substantial black population. The Barber County Democratic Executive Committee was a powerful local political body consisting of 21 members. For more than 30 years, 16 of those members had been elected from so-called beats, that is, single-member districts that were geographically drawn. But shortly after the Voting Rights Act finally enfranchised the county's black citizens, the committee changed its election procedures to elect all of the members of the committee at large. The upshot of that change was that even though black residents formed a majority of the electorate in several of the former beats, and black candidates received enough votes from those beats that if the election had been determined beat by beat, they would have won, the white county white vote defeated all of those candidates. In response to the suit that Mr. Gray filed on behalf of the county's black voters, the committee argued that the reason for the change was to comply with one person, one vote. Because, of course, if you elect at large, everybody's vote counts quantitatively exactly the same. But Judge Frank Johnson, Jr. made short work of that claim. He said, "This justification is nothing more than a sham. The measure was never seriously considered prior to the qualification of the Negro candidates and the increase in Negro voting strength. This," and he puts it in scare quotes. I hate people when they're talking and they go like that. But he says, "This coincidence," which we say coincidence, I think not, "this coincidence, together with such cavalier treatment of a measure which effectuates so basic a reform in the election procedure, is hardly probative of any motive other than racial discrimination." As in Gomillion, the court rejected the defendant's pretextual justification. But it's important to recognize that compliance with one person, one vote continues to offer jurisdictions to this very day an opportunity to manipulate electoral boundaries for partisan aim. Now, explaining why the change was racially discriminatory, Judge Johnson described its clear effect as turning black majorities into minorities in certain political areas, thereby greatly diminishing the effectiveness of their vote. Put in contemporary terms, Judge Johnson, in this first vote dilution case under the new Voting Rights Act of 1965, not only recognized the wrongfulness of racial vote dilution, but identified the mechanism by which it occurs, racial block voting, in which a black majority's black majority's choices locally are defeated by a white majority's choices globally. Virtually every Section 2 vote dilution case since Smith against Paris has involved refinements on this basic theme. Racial black voting became the linchpin of vote dilution theory. Vote dilution suits proliferated in the years after 1965. Alabama has been the site of some of the most important of this litigation. As Mr. Gray notes in the foreword to his autobiography, while Alabama had no black elected officials when he began practicing law, today the state is second in the nation in its number of black elected officials. One of the primary reasons for this is a series of lawsuits, including a massive statewide defendant class action presided over by Judge Myron Thompson, who's the stepson of one of Mr. Gray's clients in Gomillion, Kenneth Buford. That case dismantled at-large elections for school boards, for county commissions, and for city councils, and as a young lawyer, it was my privilege to work on that Dillard litigation. There's a second aspect of Smith that continues to play out in voting rights jurisprudence today. Although Judge Johnson found that the changes were unconstitutional, he refused to enjoin the upcoming election or to set aside the results afterwards. He noted that the offending change to the election process had been passed a full 6 to 7 weeks before the lawsuit was filed, and that the suit was not filed until after the election machinery had been set in motion. Thus, although the committee was enjoined from using its new system in the future, the results of the 1966 election were allowed to stand. In contemporary terms, Judge Johnson's decision was an example of what's come to be known as the Purcell Principle, named after a 2006 Supreme Court per curiam that expressed the court's reluctance to do what it called upsetting a state's electoral apparatus close to an election. That principle continues to shape voting law to this day. In this election cycle, it has clearly pushed election cases on an expedited basis, but it's also made it harder to attack late-breaking changes in election rules. In thinking about how to conclude my remarks today, I was reminded of a story in the Talmud that will resonate with what Professor Alford said earlier today. A man came to a rabbi whose name we no longer really remember, and you'll see why in a moment, and said he would convert on condition that you teach me the whole Torah while I stand on one foot. The teacher pushed him away with a measuring rod. Then the same man came before the great Rabbi Hillel with the same offer, and Hillel said to him, "What is hateful to you, do not do to your neighbor. That is the whole Torah, and the rest is commentary." In a powerful sense, all of the voting rights laws since 1957, when Fred Gray filed Gomillion against Lightfoot, in 1966, when he filed Smith against Paris, have been commentaries on the theories he advanced in those two cases. But as another saying from the Talmud reminds us, you are not obligated to complete the work, but neither are you free to desist from it. So for those of us who continue to be voting rights lawyers, Fred Gray's great work has laid down the path we continue to follow. Thank you very much.
It is a tremendous honor for me to join all of you in honoring one of this country's great civil rights lawyers and leaders, Fred Gray. I will share some thoughts later in my presentation on his contributions to the ideal of political equality, which Pam has already mentioned, and what they reveal about contemporary challenges to the right to vote. But I'd actually like to begin with the bridge metaphor that Professor Carlin mentioned. It is important to remember that when the marchers crossed the Edmund Pettus Bridge outside of Selma, they had only begun their journey. And so, if, as Representative Lewis has stated, Barack Obama was what was on the other side of that bridge, well, he's certainly not the end of the march, and we still have quite a long way to go. That reality, it seems to me, has been amply demonstrated by what is going on in the current presidential campaign. And so I actually want to proceed before talking about Fred Gray's contributions and what they reveal about contemporary struggles to that campaign and, well, the elephant in the room. Here he is. We are in the midst of a presidential campaign that is unprecedented in the history of American politics. This campaign, which has gone on for more than a year and is now in its final month, reveals a democracy that is in some serious trouble. We are deeply divided still along lines of race, ethnicity, religion, class, and political party, so much so that it has made governance, from the passing of a federal budget, keeping the United States out of default, to the confirmation of federal judges, virtually impossible. Our political discourse has declined and coarsened as the level of vituperative rhetoric has increased. More and more Americans across racial lines and across the political spectrum feel, with some justification, as though they don't have a meaningful stake or say in our current system, that their voices don't matter. And to make matters worse, some of our leaders would turn us against each other, viewing our fellow citizens, especially recent immigrants and people of color, as less than human. Racism, sexism, nativism have reappeared in our political discourse at a level that we've not seen in decades. We have a presidential candidate who talks about the African American community in caricatured terms, relying on 1970s stereotypes about the inner city, as he rails against the possibility of a, quote, rigged election, unquote. I won't do that. In scarcely veiled racial terms. I won't belabor the points about sexism, which we've heard about. In fact, that's not even a strong enough word for the misogyny that we've been inundated with over the past several days. Nativism, indeed, isn't a strong enough word for the hostility that we've seen directed towards certain groups in this election cycle, most notably Muslims and people of Mexican heritage. I feel compelled to speak about these things here before talking about the right to vote, inspired by Fred Gray's lifelong work, as he puts it, of attacking segregation, discrimination, and bigotry wherever he could find it. And although I haven't yet mentioned his name, Donald Trump, he didn't invent these divisions or the hatred that he sometimes fuels. His campaign has instead surfaced, expanded, and deepened divisions that were already present in American politics and are not new. And if you'll indulge me for just a minute more, I want to share with you why it is, at least a big part of why it is, that I do what I do working on voting rights issues and more broadly on civil rights issues. I'm, relatively speaking, a child of privilege. I haven't experienced the sort of bigotry and discrimination and hatred that some of the people sitting in this room have and had the courage to fight against. I am, however, Japanese American. And 3/4 of a century ago, as you all know, Japanese Americans, as well as Japanese nationals who were living on the West Coast, were forced to abandon their homes and sell their businesses and moved to relocation camps during World War II after the attack on Pearl Harbor. Those people included the family shown here on the lower left of the screen. The father was forced to abandon his business, a small restaurant in Santa Monica, California. The mother, she died shortly after the war. The little boy there was raised by a single father, went on to attend an integrated public high school in Los Angeles, California, to graduate from UCLA and Georgetown Medical School, and then to raise two sons. And I know this because that's my dad, who I lost a few years ago. And while he didn't really talk about this experience as a boy very often, I know that it shaped his consciousness, as did my mother, who was a white woman growing up in the segregated South. And it's a big part of why I do what I do. First, as a civil rights lawyer, working for racial justice and political equality, and more recently, in the past 13 years here in Ohio, as a member of the Ohio State Law School faculty, focusing on issues of voting rights, racial justice, and political equality. All right, so what does all this have to do with the right to vote? Well, I think the answer is everything. The Supreme Court has long held that the right to vote is fundamental because it is preservative of all rights. That is, whatever it is we care about, whatever interests we have or think we have, none of them are safe unless we're able to participate as equals in the conversations of democracy. And while the Supreme Court has often repeated these words on the screen, it has not always honored them. The irony is that at the very moment that these words became a part of our constitutional law in the 1880s, African Americans throughout the states of the former Confederacy, who had won the right to vote after the Civil War, were being disenfranchised en masse, and that would continue for the most part in the states of the former Confederacy until the Voting Rights Act of 1965 and the decisions of the Warren Court. There are multiple lessons to be learned from this history. One is that there is often a profound difference between the letter of the law and the on-the-ground reality, between the articulation of a right and its realization. Another is that we as lawyers and judges, we're not always heroes. Fred Gray is a hero, but too often our courts have looked aside, have averted their eyes in the face of threats to the right to vote. And a final lesson from this history is that progress, much as we as Americans like to believe in progress, we shouldn't trick ourselves into thinking that it's constant or inevitable. And that is exemplified by the history of the right to vote, which has been marked by short bursts of progress, followed by long periods of stagnation or even retrogression. And I would respectfully submit that we are in just such a period of retrogression when it comes to the right to vote at this moment. Now, I don't want to be too pessimistic here, because I think it is important for us also to see that people around the world still look to us in the United States, to our Constitution and our democracy, and they see hope. The promise of America still means something here and abroad. Realization of this promise, however, requires us to recover, revive, and reimagine the right to vote. The rejuvenation of our democracy, and at the risk of sounding overly dramatic, its very survival depends upon it. So, my goal in the remainder of my remarks is to try to help us expand our thinking about what the right to vote means, aided both by Fred Gray's lifelong work as well as the scholarship of my co-panelist, Professor Carlin. Um, I want to focus on three episodes from Fred Gray's life that he recounts in his autobiography, two of which, thankfully, Professor Carlin has already mentioned. So the first is, of course, the landmark decision in Gomillion versus Lightfoot, striking down the redrawing of Tuskegee's boundaries that excluded almost all the African Americans but none of the whites. This is a classic case of vote denial. Um, Second, the seminal vote dilution decision in Smith versus Paris, which Professor Carlin mentioned, and which laid the groundwork for future litigation and real change regarding minority vote dilution and minority representation, not only of African Americans, but also of Latinos and Native Americans. The third episode has not to do with cases at all, but with the experience that he recounts in his autobiography of being a member of the Alabama legislature, to which he was elected in 1970, part of the first generation of African Americans serving in Southern legislative bodies since Reconstruction. The aspect of this episode that I'd like to focus on is his quite understandable frustration that he describes in his autobiography with the process of governance. And though he won a Best Orator award from the Press Corps, Gray acknowledges that he wasn't able to pass very many bills during his tenure. As he puts it, I learned quickly that the political process is a different ballgame from the judicial process, and by the end of the term concluded that there was not a whole lot he could accomplish there. So this is where Professor Carlin comes in. These three episodes from Gray's career nicely track and illuminate three dimensions of the right to vote, which Professor Carlin analyzed in work that she did 2 decades ago, and which has been incredibly important to me in changing the way that I think about the right to vote. And that's what I want to share with you in the minutes I have left. I'm going to describe them a bit differently than Professor Carlin does in her important work on the subject, but the basic ideas are hers. So, three dimensions of the right to vote. The first is participation, right? Being able to vote and have your vote counted. I think this is probably what most people think about when they think about the right to vote, and it's still something that we struggle for today. The second is aggregation, as Professor Carlin puts it, or as I'll describe it, representation. One can have the right to vote and yet not be equally represented in legislative bodies or other elective offices. But even if one has equal participation and equal representation, it doesn't mean that you're fully equal with respect to the right to vote, because you may not still be equal when it comes to the process of governance, as Fred Gray's experience in the Alabama legislature demonstrates. So governance, or as I put it, influence, this is a third dimension to the right to vote, the least appreciated, but one that I'll argue we need to take account of. So I'm going to say just a bit in the 5 minutes or so I have left about contemporary challenges to each of these dimensions of the right to vote. Starting with participation, Pam already mentioned the North Carolina case challenging this omnibus bill that cut back voting rights in numerous respects in a way that, like the gerrymander in Gomillion versus Lightfoot, was targeted to exclude African Americans from the voting process. In some ways, we're facing the same battles today that we faced over a half century ago. Now, it's worth mentioning that these are 4 of the big cases. I'm not going to go through them all here, but 4 of the big cases that have been in the news in this election cycle, or for the states, I should say, whose voting battles have been at stake in this election cycle. Not all of these are southern states, right? Not all of these are states that were formerly covered by Section 5 of the Voting Rights Act, and one of those non-covered states is our own state here in Ohio. My friend Subodh Chandra has been working on some of this litigation, trying to ensure that the procedures used for absentee voting and provisional voting here in Ohio don't exclude people, and especially people of color. I've been working on a case, one of the one case of the three cases, unfortunately the only one that was successful before this Sixth Circuit this cycle, challenging the purging of voters from the rolls here in Ohio. Now, this battle isn't completely won yet because we've still got to go back before the district judge down in Columbus for a remedy. But the Sixth Circuit held that Ohio's practice of removing voters for their failure to vote in past elections violates the National Voter Registration Act of 1993, commonly known as the Motor Voter Law. That case is the Ohio A. Philip Randolph Institute versus Husted case, a group that I've been very happy to have and proud to have as a client. If we look a little bit more broadly, and I'm just going to touch on this briefly, I want to emphasize that as important as these cases involving the voting rules are, including cases involving early voting, we've got some deeper problems when it comes to participation. This may be a little too small to see, but there's some good news here, right? The good news is that for the last two presidential elections, black turnout has been basically at parity with white turnout, although Hispanic and Asian American turnout still lags behind. The bad news is that there are really huge differences when it comes to participation based on income and education, right? Poor people, less educated people are participating at much lower rates. And this, by the way, includes poor white voters. So I think these are problems that we need to figure out how to address as well. I'm going to skip through this in the interest of time and move to the subject very briefly of representation. So here again, we've seen some tremendous progress, and progress that shouldn't be denied. This is largely due to Section 2 of the Voting Rights Act, as well as Section 5, both of which Pam mentioned in her remarks. One of the things that I think we haven't completely confronted is the problem of gerrymandering, and relatedly, the bigger issue of polarization that is making it very difficult for our political system to accomplish the things that it needs to accomplish. This, too, I think we need to see as, without getting into too much of the details at this point, a challenge to the right to vote. I've put up here, and I'm not going to go into this in any great detail because I don't want to really bog you down with numbers, but it is an irrefutable fact that polarization among both elected officials and voters has increased markedly in recent years and decades. So I've been given the 1-minute side, which means I have to breeze through governance and influence very quickly. The single point I want to make here is that you can't talk about influence and disparities in this aspect of the right to vote without talking about money. The way money and thus power flows through our political system. In the world of election law, we tend to view voting rights issues and campaign finance issues as these separate categories. But as my friend Spencer Overton at GW Law School has noted, the way that money flows through politics affects the right to vote, including racial equality within the political process. And so I'm not gonna go through this stuff in any great detail, but here's what I want to focus on. We've seen in the years since Citizens United a tremendous increase in the amount of money that's coming not through candidates and political parties, but outside the system, these so-called independent expenditures. If you go to this next graph, we actually see the lines at the bottom crossing such that this outside spending now increases the amount of money that the parties are spending in our elections. I worked on a report that was published a couple of years ago where we talked to people across the ideological spectrum in Washington and elsewhere in the country, along with my colleague Renata Strauss, who did most of the interviews. One of the things that's amazing is that there's almost nobody who thinks this system is working very well, right? There are differences of opinion as to the causes, the reasons why it's not working well. But one of the consequences of how money flows through our political system now is that party leadership has very little ability to rein in members who are on the extreme. Right? John Boehner, Paul Ryan, Mitch McConnell, even if they wanted to, they don't have the ability to rein in their members. And there is also this tremendous feeling among people that their voices no longer matters. I think the way that money flows through politics, while not the only explanation for the abandonment that people feel, is at least a part of the reason for that. And it is something that we need to address and consider a component of the right to vote. If I could just give you one more thing here. These are sort of one data point, right? These are the results of the 2016 Republican primary. And the lighter shade are the counties that Donald Trump won in this primary, right? So our Governor John Kasich won the primary overall. But you look at these counties, if you know Ohio, you know that these places going down from northeast Ohio along the Pennsylvania and then the West Virginia border, running along the Ohio River through Appalachia. Many of these places are counties that have been struggling economically for years, right? They are predominantly white counties for the most part. They are places with terrible problems when it comes to child poverty, not only health but hunger. My wife is the executive director of the Ohio Children's Defense Fund. I think one of the few people who sees both the reality among the African American community here in Cleveland and these parts of predominantly white parts of southeastern Ohio. These folks in these counties are struggling with a terrible opioid epidemic nowadays. And I think the hardest thing, at least for many people, is this sense that their children's futures, their prospects are not as bright as their own. Not so much destitute, all of them, as downwardly mobile. And it's these people who are most susceptible to the sort of racism and sexism and nativism that we have seen in the Trump campaign. So let me just conclude by saying something that I think Fred Gray recognized in his autobiography. Voting in elections, they're ultimately about power, how it's allocated, who has it, and who doesn't. My contribution is to suggest that we think about these questions in terms of the right to vote, that we recognize the role that race, class, and party play in affirming or denying that right. Mr. Gray has spent his life fighting inequality throughout American life, and his work will not be complete until we realize the ideal of the right to vote in all of its dimensions for everyone. Our ability to preserve all of our other rights and even the sustainability of American democracy depends upon our willingness and our having the moral courage, as he has shown throughout his life, to fight for this most fundamental of all rights. Thank you very much.
Wow, thanks to both of our speakers. So we do have a few minutes for questions, if anyone wants to intervene.
On November 8th, I'm going to be a poll worker, and I will be personally telling people whether they can vote or whether they can't vote on the basis of the voter registration rolls that are going to be presented to me by the Cuyahoga County Board of Elections. So in regard to the Ohio voter purge case, Professor Tuskegee, what do you think is possible and or probable in light of a remedy with the election being so close?
Yeah. The ideal remedy would be to restore all the people who have been wrongfully purged to the rolls, but that's not realistic between now and November 8th. So what we're hoping the remedy will be is to count all the provisional ballots of those who show up at the polls on Election Day, even though their names won't appear on the registration roll if they were wrongfully purged. Moving forward after November 8th, we hope and fully expect that the remedy will be restoration of all of the people wrongfully removed to the polls, to the rolls rather.
Yes, I'm attorney Daisy Collins, retired judge. Professor
Tuskegee, yeah.
You mentioned an opinion that you thought our democracy was in danger or something to that effect. Well, I agree with you. I think that the country is in a lot of trouble right now, and if we're not careful, it will be destroyed. And I want your opinion, if you will give it to me. One of the things that I think led us to this, there are a lot of other things, but they all happened before this current election. But one of the things that led to this, in my opinion, is the failure or the refusal of the Senate Majority Leader to have an up or down vote upon the nomination made by President Barack Obama. And in effect, it appeared to me was just totally ignoring his constitutional duty, the constitutional duty of the Senate to make an up or down vote. Mm-hmm. What is your opinion on that?
I think it is most unfortunate that this highly regarded and quintessentially moderate judge, Judge Garland, has received neither a hearing nor an up or down vote. I think there's no mystery as to the reasons why that is the case. Because, look, it would represent a significant shift on the Supreme Court, especially in terms of who the median justice is on many important issues, including those pertaining to racial justice and the right to vote. So I agree with your sentiment that it is a terrible thing that Judge Garland has not yet received an up or down vote. I don't know if Pam wants to comment on this.
Yeah, my point is not so much, his qualifications, but the fundamental fact that the Constitution requires the Senate to vote, and they refuse to hold a vote. Yeah. To me, that's leading to a constitutional crisis when the elected officials willfully disobey the Constitution.
Well, I mean, here's the thing. It's no surprise that this happened, given that Senator McConnell announced at the beginning of the president's term that he viewed his job as seeing that the president would fail. which is a different conception of the job of an opposing party than we've normally had in American law. And we've moved essentially, and I think it's worth saying this, we've moved from the level of xenophobia and nativism that Dan talked about, has permeated the response to the election of President Obama as the nation's first African-American president. And it's worth, saying that this argument that he shouldn't have the ability to nominate somebody in the last year of his term is sort of like saying, we've moved from 3/5 to 7/8. And that just strikes me as an outrageous move. It's perfectly fine with me if the Republicans want to vote down Merrick Garland. That's their entitlement. And if they vote him down and hope that in the interim the presidency will change, that's their entitlement. But this idea that you shouldn't even consider somebody is ridiculous in the following sense. The framers of our Constitution knew how to write into the Constitution if they thought we should wait for an election before something important happened. They did. No, I'm serious. They did this in the 27th Amendment where they said a pay increase for Congress shouldn't go into effect until there's been another election so that people can decide. But they made federal judges independent of the next election precisely because they wanted those judges to have the courage to decide the kinds of cases that somebody like Fred Gray would bring without thinking about the next election. And this idea that the election is supposed to be a referendum on who sits on the Supreme Court and we can't have a president nominated. Well, why not just announce the day after Hillary Clinton's nominated, we need to wait for the next election? I mean, I don't see any principled reason why Mitch McConnell shouldn't make exactly the same point on January 21st, 2017 that he's made now.
One quick, but, and I hope not too cosmic question. I want to come back to a kind of a sleeper case from this past term, Evenwell against Abbott, which dealt with the population base that would be used for purposes of apportionment. The court essentially said the Constitution does not require that we use only voting age population, but left all the other hard questions open.
Right.
Where do you see that going, and what implications do you think that decision will have going forward for voting rights issues?
So I'm sure Pam has some thoughts on this as well. I think you're right to note that the most important question was left open by Evenwell. So just to fill those who may not be familiar with the Evenwell case in, we had a conservative group challenging the drawing of districts in Texas, of all places, on the ground that it violated the one person, one vote rule. Texas, of course, is not exactly your quintessentially blue state. The argument is that Texas violated the Constitution by considering everyone, not only eligible voters, but all people, including children and non-citizens, when drawing district lines. And the conservative group that brought the Evenwell case claimed that this was a violation of one person, one vote. That's actually the way that all of the states draw their district lines, not just Texas. So not surprisingly, the Supreme Court rejected this challenge. What's still up in the air, and the next big case, is what if a state like Texas decides not to count children or non-citizens or other people who aren't eligible or registered voters in the next redistricting cycle? That is quite plausible because, look, if Texas is a state that is now solidly red, but could get bluer in the years to come, largely because of its increasing Latino population, it is quite conceivable that a future Republican Texas legislature might decide that it is in their interests to no longer count children and non-citizens when drawing its district lines, and the question then will be, does that violate one person, one vote? I think there's language in the opinion that Justice Ginsburg wrote for the court which helps the argument that it is a violation of one, or would be a violation of one person, one vote for a state to do this, but the court is very clear that it is not, that it was not deciding that issue in Evenwell.
And I'll just add one very brief Alabama wrinkle to this, which is In addition to children not being able to vote and non-citizens not being able to vote, there's another group of Americans who aren't able to vote, and those are people who've been convicted of crimes. In some states, there's lifetime disenfranchisement. Alabama has a law that disenfranchises people based on having committed crimes of moral turpitude, which the state nowhere defines, and so people don't know whether they're entitled to vote or not. And we filed a lawsuit last month in Alabama challenging this provision of Alabama law, in part because it comes out of the same 1901 Constitutional Convention that was designed to disenfranchise every black person in Alabama. And I just want, for those of you who don't understand the impact of this nationwide, to make a point. I calculated this a couple of years ago, that more black men are disenfranchised today by offender disenfranchisement provisions than the 15th Amendment enfranchised in 1870. That is, if you add up the number of black men in this country who were over the age of 21 in 1870, it's fewer than the number of black men who are disenfranchised today. 1 out of every 13 black men in Alabama can't vote. And so Evanwell is not just about the attempt of some conservatives to prevent the increase in Latino population from playing out in the electoral process, but it also may have implications for the African American population as well.
Thank you. Unfortunately, I think we have to wrap up the discussion in the interest of time. We now have the extended lunch break, and we'll reconvene at 1:45. Thanks very much.